A treaty is a formal, legally binding written agreement between two or more sovereign states or international organizations, governed by international law, establishing rights and obligations between them, and covering subjects from peace and trade to human rights, often known by other names like conventions or protocols. The key is the intent to create international legal commitments, not the specific title, and they can be bilateral, two parties, or multilateral, multiple. Treaties are crucial for formalizing international relations and ensuring compliance with agreed-upon rules. A treaty is a recorded international agreement between sovereign states or other subjects of international law, including international organizations, that is governed by international law. A treaty may also be known as an international agreement, protocol, covenant, convention, pact, or exchange of letters, among other terms. However, only documents that are legally binding on the parties are considered treaties under international law. Treaties may be bilateral, between two countries, or multilateral, involving more than two countries. International agreements were used in some form by most major civilizations and became increasingly common and more sophisticated during the early modern era. The early 19th century saw developments in diplomacy, foreign policy, and international law reflected by the widespread use of treaties. The 1969 Vienna Convention on the Law of Treaties, VCLT, codified these practices and established rules and guidelines for creating, amending, interpreting, and terminating treaties, and for resolving disputes and alleged breaches. They vary in their obligations, the extent to which states are bound to the rules, precision, the extent to which the rules are unambiguous, and delegation, the extent to which third parties have authority to interpret, apply, and make rules. Treaties can take many forms and govern a wide range of subject matters, such as security, trade, environment, and human rights. They may also be used to establish international institutions, such as the International Criminal Court and the United Nations, for which they often provide a governing framework. Treaties serve as primary sources of international law and have codified or established most international legal principles since the early 20th century. In contrast with other sources of international law, such as customary international law, treaties are only binding on the parties that have signed and ratified them. Notwithstanding the VCLT and customary international law, treaties are not required to follow any standard form, and differ widely in substance and complexity. Nevertheless, all valid treaties must comply with the legal principle of pacta sunt servanda, Latin, agreements must be kept, under which parties are committed to perform their duties and honor their agreements in good faith. A treaty may also be invalidated, and thus rendered unenforceable, if it violates a peremptory norm, jus cogens, such as permitting a war of aggression or crimes against humanity. Modern usage and form. A treaty is an official, express written agreement that states use to legally bind themselves. It is also the objective outcome of a ceremonial occasion that acknowledges the parties and their defined relationships. There is no prerequisite of academic accreditation or cross-professional contextual knowledge required to publish a treaty. However, since the late 19th century, most treaties have followed a fairly consistent format. A treaty typically begins with a preamble describing the high contracting parties and their shared objectives in executing the treaty, as well as summarizing any underlying events, such as the aftermath of a war in the case of a peace treaty. Modern preambles are sometimes structured as a single very long sentence formatted into multiple paragraphs for readability, in which each of the paragraphs begins with a gerund, desiring, recognizing, having, etc. The high contracting parties referred to as either the official title of the head of state, but not including the personal name, e.g. His Majesty the King of X or His Excellency the President of Y, or alternatively in the form of Government of Z are enumerated, along with the full names and titles of their plenipotentiary representatives. A boilerplate clause describes how each party's representatives have communicated, or exchanged, their full powers, i.e., the official documents appointing them to act on behalf of their respective high contracting party, and found them in good or proper form. However, under the Vienna Convention on the Law of Treaties, if the representative is the head of state, head of government or Minister of Foreign Affairs, no special document is needed, as holding such high office is sufficient. The end of the preamble and the start of the actual agreement is often signaled by the words "have agreed" as follows. After the preamble comes numbered articles, which contain the substance of the parties' actual agreement. Each article heading usually encompasses a paragraph. A long treaty may further group articles under chapter headings. Modern treaties, regardless of subject matter, usually contain articles governing where the final authentic copies of the treaty will be deposited and how any subsequent disputes as to their interpretation will be peacefully resolved. The end of a treaty, the eschatokol, or closing protocol, is often signaled by language such as "in witness whereof" or "in faith whereof," followed by the words "done at," then the site, s, of the treaty's execution and the date, s, of its execution. The date is typically written in its most formal, non-numerical form. For example, the Charter of the United Nations reads "done at the city of San Francisco the 26th day of June, 1945. If applicable, a treaty will note that it is executed in multiple copies in different languages, with a stipulation that the versions in different languages are equally authentic. The signatures of the parties' representatives follow at the very end. When the text of a treaty is later reprinted, such as in a collection of treaties currently in effect, an editor will often append the dates on which the respective parties ratified the treaty and on which it came into effect for each party. Bilateral and multilateral treaties. Bilateral treaties are concluded between two states or entities. It is possible for a bilateral treaty to have more than two parties. For example, each of the bilateral treaties between Switzerland and the European Union, EU, has 17 parties. The parties are divided into two groups, the Swiss, on the one part, and the EU and its member states, on the other part. The treaty establishes rights and obligations between the Swiss and the EU and the member states severally. It does not establish any rights and obligations amongst the EU and its member states. A multilateral treaty is concluded among several countries, establishing rights and obligations between each party and every other party. Multilateral treaties may be regional or may involve states across the world. Treaties of mutual guarantee are international compacts. Example: the Treaty of Locarno, which guarantees each signatory against attack from another. Role of the United Nations. The United Nations has extensive power to convene states to enact large-scale multilateral treaties and has experience doing so. Under the United Nations Charter, which is itself a treaty, treaties must be registered with the UN to be invoked before it, or enforced in its judiciary organ, the International Court of Justice. This was done to prevent the practice of secret treaties, which proliferated in the 19th and 20th centuries and often precipitated or exacerbated conflict. Article 103 of the Charter also states that its members' obligations under the Charter outweigh any competing obligations under other treaties. After their adoption, treaties, as well as their amendments, must follow the official legal procedures of the United Nations, as applied by the Office of Legal Affairs, including signature, ratification, and entry into force. In function and effectiveness, the UN has been compared to the United States federal government under the Articles of Confederation. Adding and amending treaty obligations. Reservations are essentially caveats to a state's acceptance of a treaty. Reservations are unilateral statements purporting to exclude or to modify the legal obligation and its effects on the reserving state. These must be included at the time of signing or ratification, i.e., a party cannot add a reservation after it has already joined a treaty. Article 19 of the Vienna Convention on the Law of Treaties in 1969. Originally, international law was unaccepting of treaty reservations, rejecting them unless all parties to the treaty accepted the same reservations. However, in the interest of encouraging the largest number of states to join treaties, a more permissive rule regarding reservations has emerged. While some treaties still expressly forbid any reservations, they are now generally permitted to the extent that they are not inconsistent with the goals and purposes of the treaty. When a state limits its treaty obligations through reservations, other states party to that treaty have the option to accept those reservations, object to them, or object and oppose them. If the state accepts them, or fails to act at all, both the reserving state and the accepting state are relieved of the reserved legal obligation as concerns their legal obligations to each other. Accepting the reservation does not change the accepting state's legal obligations as concerns other parties to the treaty. If the state opposes, the parts of the treaty affected by the reservation drop out completely and no longer create any legal obligations on the reserving and accepting state, again only as concerns each other. Finally, if the state objects and opposes, there are no legal obligations under that treaty between those two state parties whatsoever. The objecting and opposing state essentially refuses to acknowledge the reserving state is a party to the treaty at all. Amendments. There are three ways an existing treaty can be amended. First, a formal amendment requires state parties to the treaty to go through the ratification process all over again. The renegotiation of treaty provisions can be long and protracted, and often some parties to the original treaty will not become parties to the amended treaty. When determining the legal obligations of states, one party to the original treaty and one party to the amended treaty, the states will only be bound by the terms they both agreed upon. Treaties can also be amended informally by the Treaty Executive Council when the changes are only procedural. Technical change in customary international law can also amend a treaty, where state behavior evinces a new interpretation of the legal obligations under the treaty. Minor corrections to a treaty may be adopted by a procès-verbal, but a procès-verbal is generally reserved for changes to rectify obvious errors in the text adopted, i.e., where the text adopted does not correctly reflect the intention of the parties adopting it. Protocols. In international law and international relations, a protocol is generally a treaty or international agreement that supplements a previous treaty or international agreement. A protocol can amend the previous treaty or add additional provisions. Parties to the earlier agreement are not required to adopt the protocol, and this is sometimes made explicit, especially where many parties to the first agreement do not support the protocol. A notable example is the United Nations Framework Convention on Climate Change, UNFCCC, which established a general framework for the development of binding greenhouse gas emission limits, followed by the Kyoto Protocol contained the specific provisions and regulations later agreed upon. Execution and implementation. Treaties may be seen as self-executing, in that merely becoming a party puts the treaty and all its obligations in action. Other treaties may be non-self-executing and require implementing legislation, a change in the domestic law of a state party that will direct or enable it to fulfill treaty obligations. An example of a treaty requiring such legislation would be one mandating local prosecution by a party for particular crimes. The division between the two is often unclear and subject to disagreements within a government, since a non-self-executing treaty cannot be acted on without the proper change in domestic law. If a treaty requires implementing legislation, a state may default on its obligations due to its legislature failing to pass the necessary domestic laws. Interpretation. The language of treaties, like that of any law or contract, must be interpreted when the wording does not seem clear, or it is not immediately apparent how it should be applied in a perhaps unforeseen circumstance. The Vienna Convention states that treaties are to be interpreted in good faith according to the ordinary meaning given to the terms of the treaty in their context and in the light of its object and purpose. International legal experts also often invoke the principle of maximum effectiveness, which interprets treaty language as having the fullest force and effect possible to establish obligations between the parties. No one party to a treaty can impose its particular interpretation of the treaty upon the other parties. Consent may be implied, however, if the other parties fail to explicitly disavow that initially unilateral interpretation, particularly if that state has acted upon its view of the treaty without complaint. Consent by all parties to the treaty to a particular interpretation has the legal effect of adding another clause to the treaty. This is commonly called an authentic interpretation. International tribunals and arbiters are often called upon to resolve substantial disputes over treaty interpretations. To establish the meaning in context, these judicial bodies may review the preparatory work from the negotiation and drafting of the treaty as well as the final, signed treaty itself. Consequences of terminology. One significant part of treaty making is that signing a treaty implies a recognition that the other side is a sovereign state and that the agreement being considered is enforceable under international law. Hence, nations can be very careful about terming an agreement to be a treaty. For example, within the United States, agreements between states are compacts and agreements between states and the federal government or between agencies of the government are memoranda of understanding. Another situation can occur when one party wishes to create an obligation under international law, but the other party does not. This factor has been at work with respect to discussions between North Korea and the United States over security guarantees and nuclear proliferation. The definition of the English word treaty varies depending on the legal and political context. In some jurisdictions, such as the United States, a treaty is specifically an international agreement that has been ratified, and thus made binding, per the procedures established under domestic law. Enforcement. While the Vienna Convention provides a general dispute resolution mechanism, many treaties specify a process outside the convention for arbitrating disputes and alleged breaches. This may by a specially convened panel, by reference to an existing court or panel established for the purpose such as the International Court of Justice, the European Court of Justice or processes such as the Dispute Settlement Understanding of the World Trade Organization. Depending on the treaty, such a process may result in financial penalties or other enforcement action. Ending treaty obligations. Withdrawal. Treaties are not necessarily permanently binding upon the signatory parties. As obligations in international law are traditionally viewed as arising only from the consent of states, many treaties expressly allow a state to withdraw as long as it follows certain procedures of notification, denunciation. For example, the Single Convention on Narcotic Drugs provides that the treaty will terminate if, as a result of denunciations, the number of parties falls below 40. Many treaties expressly forbid withdrawal. Article 56 of the Vienna Convention on the Law of Treaties provides that where a treaty is silent over whether or not it can be denounced, there is a rebuttable presumption that it cannot be unilaterally denounced unless it can be shown that the parties intended to admit the possibility, or a right of withdrawal can be inferred from the terms of the treaty. The possibility of withdrawal depends on the terms of the treaty and its travaux preparatory. It has, for example, been held that it is not possible to withdraw from the International Covenant on Civil and Political Rights. When North Korea declared its intention to do this, the Secretary-General of the United Nations, acting as registrar, said that original signatories of the ACPAIR had not overlooked the possibility of explicitly providing for withdrawal, but rather had deliberately intended not to provide for it. Consequently, withdrawal was not possible. The Organization of American States, OAS, offers the ability of member states to withdraw from its framework by allowing states to officially inform the General Secretariat of the OAS of such intended withdrawal and being subject to a 2-year-long sunset period in accordance with Article 143 of the body's charter. In practice, state legislatures, or other officials where so structured, sometimes use their sovereignty or provisions of supreme law to declare their withdrawal from and stop following the terms of a treaty even if this violates the terms of the treaty. Other parties may accept this outcome, may consider the state to be untrustworthy in future dealings, or may retaliate with sanctions or military action. Withdrawal by one party from a bilateral treaty is typically considered to terminate the treaty. Multilateral treaties typically continue even after the withdrawal of one member, unless the terms of the treaty or mutual agreement causes its termination. Suspension and termination. If a party has materially violated or breached its treaty obligations, the other parties may invoke this breach as grounds for temporarily suspending their obligations to that party under the treaty. A material breach may also be invoked as grounds for permanently terminating the treaty itself. A treaty breach does not automatically suspend or terminate treaty relations, however. It depends on how the other parties regard the breach and how they resolve to respond to it. Sometimes treaties will provide for the seriousness of a breach to be determined by a tribunal or other independent arbiter. An advantage of such an arbiter is that it prevents a party from prematurely and perhaps wrongfully suspending or terminating its own obligations due to another's alleged material breach. Treaties sometimes include provisions for self-termination, meaning that the treaty is automatically terminated if certain defined conditions are met. Some treaties are intended by the parties to be only temporarily binding and are set to expire on a given date. Other treaties may self-terminate if the treaty is meant to exist only under certain conditions. A party may claim that a treaty should be terminated, even absent an express provision, if there has been a fundamental change in circumstances. Such a change is sufficient if unforeseen, if it undermines the essential basis of consent by a party, if it radically transforms the extent of obligations between the parties, and if the obligations are still to be performed. A party cannot base this claim on change brought about by its own breach of the treaty. This claim also cannot be used to invalidate treaties that established or redrew political boundaries. Cartels were a special kind of treaty within the international law of the 17th to 19th centuries. Their purpose was to regulate specific activities of common interest among contracting states that otherwise remained rivals in other areas. They were typically implemented on an administrative level. Similar to the cartels for duels and tournaments, these intergovernmental accords represented fairness agreements or gentlemen's agreements between states. In the United States, cartels governed humanitarian actions typically carried out by cartel ships were dispatched for missions, such as to carry communications or prisoners between belligerents. From the European history, a broader range of purposes is known. These cartels often reflected the cohesion of authoritarian ruling classes against their own unruly citizens. Generally, the European governments concluded, while curbing their mutual rivalries partially, cooperation agreements, which should apply generally or only in case of war. Deserters, escaped serfs, and criminals were to be mutually extradited. Prisoners of war should be handed out according to rank in different exchange ratios. The maintenance of postal and commercial traffic, including the entry and exit of couriers, should be guaranteed in the fields of communication and transport. Customs cartels, Zollkartel, and coin cartels, Mundskartel, were regulatory agreements between continental European states in the 19th century. Against smugglers and counterfeiters, a joint action approach was adopted by the governments contracting on international trade treaties. The latter often contain the relevant cartel regulations in their annexes. The measures against criminals and unruly citizens were to be conducted regardless of the nationality and origin of the relevant persons. If necessary, national borders could be crossed by police forces of the respective neighboring country for capture and arrest. In the course of the 19th century, the term cartel, or cartel, gradually disappeared for intergovernmental agreements under international law. Instead, the term convention was used. Invalid treaties. An otherwise valid and agreed upon treaty may be rejected as a binding international agreement on several grounds. For example, the Japan-Korea treaties of 1905, 1907, and 1910 were protested by several governments as having been essentially forced upon Korea by Japan. 33 They were confirmed as already null and void in the 1965 Treaty on Basic Relations between Japan and the Republic of Korea. Ultra vires treaties. If an act or lack thereof is condemned under international law, the act will not assume international legality even if approved by internal law. This means that in case of a conflict with domestic law, international law will always prevail. A party's consent to a treaty is invalid if it had been given by an agent or body without power to do so under that state's domestic laws. States are reluctant to inquire into the internal affairs and processes of other states, and so a manifest violation is required such that it would be objectively evident to any state dealing with the matter. A strong presumption exists internationally that a head of state has acted within his proper authority. It seems that no treaty has ever actually been invalidated on this provision. Consent is also invalid if it was given by a representative acting outside their restricted powers during the negotiations, if the other parties to the treaty were notified of those restrictions prior to his or her signing. Misunderstanding, fraud, corruption, coercion. Articles 46 to 53 of the Vienna Convention on the Law of Treaties set out the only ways that treaties can be invalidated, considered unenforceable and void under international law. A treaty will be invalidated due to either the circumstances by which a state party joined the treaty or due to the content of the treaty itself. Invalidation is separate from withdrawal, suspension, or termination, addressed above, which all involve an alteration in the consent of the parties of a previously valid treaty rather than the invalidation of that consent in the first place. A governmental leader's consent may be invalidated if there was an erroneous understanding of a fact or situation at the time of conclusion, which formed the essential basis of the state's consent. Consent will not be invalidated if the misunderstanding was due to the state's own conduct, or if the truth should have been evident. Consent will also be invalidated if it was induced by the fraudulent conduct of another party, or by the direct or indirect corruption of its representative by another party to the treaty. Coercion of either a representative or the state itself through the threat or use of force, if used to obtain the consent of that state to a treaty, will invalidate that consent. Contrary to peremptory norms. A treaty is null and void if it is in violation of a peremptory norm. These norms, unlike other principles of customary law, are recognized as permitting no violations and so cannot be altered through treaty obligations. These are limited to such universally accepted prohibitions as those against the aggressive use of force, genocide, and other crimes against humanity, piracy, hostilities directed at civilian population, racial discrimination and apartheid, slavery and torture, meaning that no state can legally assume an obligation to commit or permit such acts. Treaty, a binding formal agreement, contract, or other written instrument that establishes obligations between two or more subjects of international law, primarily states and international organizations. The rules concerning treaties between states are contained in the Vienna Convention on the Law of Treaties, 1969, and those between states and international organizations appear in the Vienna Convention on the Law of Treaties between states and international organizations or between international organizations, 1986. The term treaty is used generically to describe a variety of instruments, including conventions, agreements, arrangements, protocols, covenants, charters, and acts. In the strict sense of the term, however, many such instruments are not treaties. The key distinguishing feature of a treaty is that it is binding. For example, whereas the United Nations, UN, Charter, 1945, created a binding agreement and is thus a treaty, the Charter of Paris, 1990, which established the Organization for Security and Cooperation in Europe, formerly the Conference on Security and Cooperation in Europe, is not a binding document as such and thus is not officially a treaty. Treaties are expected to be executed in good faith, in keeping with the principle of pacta sunt servanda, Latin, agreements must be kept, arguably the oldest principle of international law. Without this principle, which is explicitly mentioned in many agreements, treaties would be neither binding nor enforceable. A treaty is normally negotiated between plenipotentiaries provided by their respective governments with the full power to conclude a treaty within the scope of their instructions. A country's signature is often sufficient to manifest its intention to be bound by the treaty, especially in the case of bilateral treaties. In multilateral, general, treaties, however, a country's signature is normally subject to formal ratification by the government unless it has explicitly waived this right. Apart from such an express provision, the instrument does not become formally binding until ratifications have been exchanged. Multilateral treaties bind only those states that are parties to them and go into effect after a specified number of ratifications have been attained. After the time specified for states to sign the treaty has passed, states may become parties to the treaty through a process known as accession. The use of multilateral treaties has increased dramatically since the early 20th century, example the 1919 Treaty of Versailles and the 1945 UN Charter. Such treaties have proved to be effective in establishing new rules of international law, particularly where there is a need to respond quickly to changing circumstances or where the issue in question is unregulated. An example of the former kind of treaty is the Convention on the Law of the Sea, which was signed in 1982 and came into force 12 years later. This comprehensive treaty, which took more than a decade to negotiate, specifies the status of the seas and the international seabed. Examples of the latter kind of treaty include a range of environmental treaties, such as the Geneva Convention on Long-Range Transboundary Air Pollution, 1979, and the Vienna Convention for the Protection of the Ozone Layer, 1985, as well as their succeeding protocols, the UN Framework Convention on Climate Change, UNFUC, and the Convention on Biological Diversity, both of which were adopted in 1992, and the Kyoto Protocol, 1997, the first addition to the UNFUC, which was superseded by the Paris Agreement on Climate Change in 2015. In addition, human rights protections have been expanded tremendously through a series of international conventions and regional agreements, including the Convention on the Prevention and Punishment of the Crime of Genocide, 1948, the European Convention on Human Rights, 1950, the International Convention on the Elimination of All Forms of Racial Discrimination, 1965, the International Covenant on Economic, Social, and Cultural Rights, 1966, the International Covenant on Civil and Political Rights, 1966, and the Inter-American Convention on Human Rights, 1969. Treaties do not need to follow any special form. A treaty often takes the form of a contract, but it may be a joint declaration or an exchange of notes, as in the case of the Rush-Bagot Agreement between the United States and Great Britain in 1817 for mutual disarmament on the Great Lakes. Important treaties, however, generally follow a fixed plan. The preamble provides the names and styles of the contracting parties and is a statement of the treaty's general objectives. It is usually followed by the articles containing the agreed-upon stipulations. If the treaty is concluded for a definite period, a statement of the period follows, or, if it is in perpetuity, there may be a provision inserted that either party may denounce, i.e., give notice to terminate, the treaty. Any reservations, which alter the treaty's provisions for the concerned state, may then appear. They are followed by an article that provides for the treaty's ratification and for the time and place for the exchange of ratifications. The treaty usually ends with a clause stating that in witness whereof the respective plenipotentiaries have affixed their names and seals, below which are the signatures and indications of the location and the date. Additional articles often are appended and signed by the plenipotentiaries, with the declaration that they have the same force and value as if they had been included in the body of the treaty or convention. International jurists have classified treaties according to a variety of principles. In addition to the distinction between multilateral and bilateral treaties, there is also the distinction between treaties representing a definite transaction, example a cession of territory, and those seeking to establish a general rule of conduct, example the renunciation of war. Treaties also have been classified according to their object, as follows: 1. Political treaties, including peace treaties, alliances, territorial cessions, and disarmament treaties. 2. Commercial treaties, including tariff, consular, fishery, and navigation agreements. 3. Constitutional and administrative treaties, such as the conventions establishing and regulating international unions, organizations, and specialized agencies. 4. Treaties relating to criminal justice, such as the treaties defining international crimes and providing for extradition. 5. Treaties relating to civil justice, such as the conventions for the protection of human rights, for trademarks and copyright, and for the execution of the judgments of foreign courts. And 6. Treaties codifying international law, such as the procedures for the peaceful settlement of international disputes, rules for the conduct of war, and definitions of the rights and duties of states. In practice, it is often difficult to assign a particular treaty to any one of these classes, and the legal value of such distinctions is minimal. Treaties may be terminated or suspended through a provision in the treaty, if one exists, or by the consent of the parties. In the case of a material breach, i.e., an impermissible repudiation of the treaty or a violation of a provision essential to the treaty's object or purpose, the innocent party of a bilateral treaty may invoke that breach as a ground for terminating the treaty or suspending its operation. Multilateral treaties may be terminated or suspended by the unanimous agreement of all their parties. A party specially affected by a breach of a multilateral treaty may suspend the agreement as it applies to relations between itself and the defaulting state. In cases where a breach by one party significantly affects all other parties to the treaty, the other parties may suspend the entire agreement or a part of it. Thank you for watching this video.